All right, good afternoon. Thanks for being here, and for all of you that are online. My name's Steve Pierce. I see a lot of new faces here. Actually, I think it's the first time I've taught a class in person for a year and a half, maybe.
I was going to say, since
It's been a long time. I almost forgot how to do it. Today's class is going to be on forms. For those of you that may not know me or know my background, I have been a real estate broker for over 31 years. I've been an attorney for too long, over 38 years. Actually, I think it's 39 now, or it will soon be 39. I've been with Keller Williams for over 20 years. I'm the broker, founding owner, and operating principal of Bismarck Center, and I serve as the risk management director for the Pleasanton and Livermore offices as well. Right off the bat, what I want to explain to you about the format of this class is I'm going to take you through probably 80 to 90% of all the forms that are in zip forms. And my goal is to just allow you to be aware of the forms, to recognize the forms, know that they're there, and basically what they're there for. Okay, because a lot of times agents will start trying to write an addendum and put something down, and they don't realize that a form exists for it. You always want to rely on the form first before you start to try to write something out yourself. Okay, I always tell agents have lived before you. It's very unlikely that you're going to be faced with a situation that someone hasn't been faced with before, which means there likely is a form for what it is you're about to write out. So that's always the first thing you got to ask yourself. Do I need to be doing this? Is there already a form? Chances are there are. And once we go through all these today, you'll be aware of a lot of the forms, the most commonly used forms. So it should help you going forward. The other thing that's really important is that, I mean, I didn't even count how many forms we have here. It's incumbent upon you to read these forms, understand these forms, ask questions about these forms before you are sitting in front of a client, before you have a client who you are preparing documents to send because you've got an offer deadline in the next 30 to 60 minutes. That's not the time to be trying to figure out what these forms say, what they mean, how to check the boxes, and so forth. This is what everyone outside of real estate, this is what everyone refers to as the paperwork. All people think we do is just fill out paperwork. Well, this is just a good portion of what it is, but there's a lot of information in this paperwork. There's consequences to what that paperwork says. Just checking one box wrong could change the entire outcome of their interpretation of that form. So my point is, yes, it's paperwork. It's important paperwork. And if you make mistakes in the forms, you could jeopardize your client's position. One of the questions that I get all the time from agents is when an issue arises and they send me an email, and the question they'll always ask is, what can I do to protect my client? That's what everyone loves. That phrase, I see it all the time. What can I do to protect my client? The answer quite often is, make sure you're using the right form or paperwork, because that's what this is for. That's what it's all about. It's to protect your client. That's why we have all this paperwork, all these documents and forms. So that's always the first thing you got to remember is it's faced with a situation, there's likely a form that addresses it. If there's not, that's when you then need to ask questions. You need to reach out to me, Jason, your mentor, someone else's experience, and ask them, here's my situation, what do I do? How should I address it? Okay. Another thing to think about when you are preparing any kind of addendum or term to a contract, don't just start typing what I call a stream of consciousness. Don't type like you talk. That's not how you prepare contractual terms. Think about a similar clause or term that's in a form already and go back to that and use that, mimic that form to draft what you need to draft. That's what I do all the time. I don't just go off a stream of consciousness in my head. I go back, I go, what is similar in a form to what I want to say in an addendum, for example, or in a counteroffer? I go back and refer to another document that's already been drafted by attorneys and has already been tested and proven. Does that make sense?
Can you give us an example?
Okay. Let's say you're going to just a simple thing like you're going to write an extension of time addendum, but for some reason you're not using that form. You're using it on an addendum. You're using an addendum to put that down, to write that down. What you want to say is, you don't want to say when it comes to extending close of escrow. A lot of agents will do an addendum and say close of escrow to be, put that date. That's not what you want to say. You want to say the scheduled close of escrow date to be, because that means that's what it's scheduled, but it may not happen on that day. See, when you say close of escrow to be that date, when you're doing an extension, that already tells you it didn't happen on the day you already thought escrow was going to close. So you're scheduling another date. Well, that date could move out again. Okay. So that if you look at a form, you'll see that's what, when you look at the extension of time addendum and you look at the clause that refers to extending the close date, those are the words it uses. That answer your question? Again, it's just go back to the form and use the language in the form. So as I said earlier, you need to read these forms. Every form you use, you need to read it before you use it, before you give it to a client. Think about it. What are you going to say if you hand a form to a client or you email them a form? You set up a zip form and say, please, I need you to sign this document. And they pick up the phone and they ask you a question. What does this mean? Well, if you haven't read the form, you haven't familiarized with the form, how are you going to answer that question? So you got to go through these. And I know it's a lot of work and it's a lot of reading, but you've got to do it. If you're new in the business, you need to be taking the time, take an hour out of your day or night every day to be reading at least 1 or 2 or 3 forms. So you know what they say, you know what they mean. And if you have questions, you highlight them, you mark them up, and you come ask somebody. Ask me, ask Jason, ask your mentor. What does this mean? I still, to this day, we have forms that agents have been filling out for years, and I still see them written with errors. The wrong boxes are checked. What's that tell me? It tells me you're not reading the form. You're going through the motions. You're looking at it real quick. You think this is the right box, but you're not carefully reading the form. And what you need to understand is there can be legal consequences to not checking the right boxes. Does that all make sense? And I'm making a big deal about this because I see it all of the time. It continually happens over and over again. And it's even worse when we end up with a dispute between the two parties. And now we're going down a legal path trying to resolve an issue. And then I have to look at the forms that our agent prepared. And then I cringe when I see what was written, what was checked, or what wasn't written or wasn't checked. So I hope that resonates with you. But you're going to walk out of here, and your mind might be overwhelmed by the amount of forms we're going through. And I understand there's a lot here, but my point is you can't just walk out here and go, okay, got it. I know what all these forms are. When that happens, I'm just going to pull this. You got to read these forms. You got to know what they say. Yes.
Do you advise chance to give the form to a buyer?
Give what form to a buyer?
Purchase.
Yes. Yes, anytime I ever teach a class that deals with remotely with an initial buyer consultation, one of the things that I recommend is that you provide the buyer with a sample purchase agreement. Sample statewide buyer and seller advisory, Alameda County disclosure advisory if you're in if the property's in Alameda County. There's a whole host of documents that you can prepare as part of a package with in your initial buyer consultation, which will help you create value and get the buyer to sign a buyer representation agreement. That should be part of your presentation. Now, here's the other thing, folks, is you got to remember, if your goal is to have a buyer sign a buyer representation agreement, you don't give them those documents unless they sign it. That makes sense? You dangle the carrot in front of them and say, I've got all this information and I'm willing to share it with you if you're willing to commit to work with me.
So first you make them sign the buyer representation.
In other words, you don't you prepare your package, you show them everything that you want to go over with them, and you can go over it with them, but you're not going to give it physically to them unless they sign the agreement. That strategy's been around since day one, from the very first time we ever had broker buyer rep agreements, okay? So the first thing that I want to share with you is, there's a little known site in Zip Forms that contains what are called CAR sample letters. And I don't think there's that many agents or even brokers that are aware of these letters. And what I just provided you is a list of all of the sample letters that are in Zip Forms. When you go into Zip Forms and you open it up in the top right-hand corner, it has CAR Association of Realtors. Well, if you click on the arrow, down arrow to the right of that, it's going to open up a menu of more sites. And one of those sites is CAR sample letters. And a lot of these letters are pre-written for a lot of situations that you may come into, and they are set up in a fillable format where all you got to do, the letter's written, you just got to plug in all the facts from your transaction. Now, I'm not going to spend time going through all of this. I just want to make you aware of the letters. One that's really important is if you're in a situation where your client is going to do something that's against your advice, something that, as brokers, we recommend you do this. And if the client wants to do something against our advice, there is a letter in this sample list where you can document that and give the letter to the client documenting that they are acting against our advice, the broker's advice. And that can be a really important one. All right, let's get started on the forms. The other thing I want you to understand is there's a lot of forms. I'm going to go through them one at a time. I can't spend a lot of time going through each one in detail. If you have questions, you can always reach out to me by email, text. I'll be more than happy to answer any specific questions you have. For those of you that are in the room, if you have a question about a form, a burning question, just raise your hand. We'll answer it. Those of you that are online, you can put in questions in the chat. Jason's here. He's helping me. He's my Vanna today.
I am.
I don't mind the questions, and the other thing is try to avoid specific questions dealing with a transaction that you're currently involved in. Let's save that for offline after the class. Otherwise, we'll get bogged down because we've got quite a few forms to go through. Now, the next thing I want to share with you is what I've done is I've put these forms in what I call a chronological sequence based on your representations and interactions with clients. So the first couple of documents deal with the potential where you're not going to represent the client. You're going to refer them out. Then the next group of documents are all going to be assuming you are going to be pursuing a listing with the seller. And then the third set of documents are going to be documents where you're preparing an offer on behalf of a buyer. And then it'll take you through all the forms. And I've put them all basically in a logical sequence instead of having you just go into zip forms and look at them in alphabetical order. So the first document you need to be aware of is a referral fee agreement. If you get a lead from someone and they're a buyer or a seller and they're not in reasonable proximity to where you live or work, then the best thing to do is to refer them out. I refer buyers and sellers out on almost a weekly basis. There's a certain distance that I'm willing to drive to manage a listing and or willing to drive to show buyer property. Now, I teach a whole nother class on time management, and that's part of the issue with going out far is time management. The other is, are you even aware of what's going on in that area or community? You can get yourself in a lot of trouble as a listing agent if you start going too far out of the area that you work, because you don't know what's happening in that community. And that can get you in a lot of trouble. That's why we refer out sellers beyond a certain point in time. Now, I've represented buyers in Boulder Creek, but just 3 weeks ago, I got a referral in Boulder Creek to list a house from my past client for whom I've already listed 3 properties. I asked myself, I'm swamped right now. Do I want to try to service about a $400,000 cabin in Boulder Creek? No, it's not in my wheelhouse. So I reached out to Jason, actually, because he's formerly from Santa Cruz. I said, I need a good listing agent, serves Boulder Creek. My client's hooked up with that agent. I'll get 25% for making a phone call. Okay. Now, and I think this year I've had several, and I've got more referrals that are in the pipeline. Remember, with a 25% referral fee, for every 4 referrals you make, you just made a commission. There are agents in this business who just lead generate to refer out. Think about that from a time management standpoint. Find the lead, refer it out, get 25%. Move on and do another one. Every 4 is one commission. Now, one thing that happens, we're in a very diverse community. You get a lead, they speak a foreign language that you don't speak. What's the knee-jerk reaction for most agents to do? Refer it out. Refer it out, take 25%. Sounds good, makes sense. Here's another alternative. You can hire an interpreter. Now, does anybody know how much an interpreter charges per hour? Now, it can vary from $25 to $30 to $40 to $50 to $60 an hour. Now, ask yourself, how many hours might you have to rely on an interpreter to interpret documents with the client? Multiply that number of hours by $60 an hour. How many hours do you think it might be? 20 hours, 30 hours? Someone get out the calculator. What's 25 hours at $60 an hour?
$1,500.
$1,500 for an interpreter. Now, how much, let's say it's $1 million house. You're going to list it for 6%. You're going to get 3%. What's 75% of 3% of $1 million? That's what you're giving up. When you refer it out, you're taking 25% of 3%, and letting the other agent earn the other 75%. You're giving up that 75% when you could be getting that also by paying an interpreter. Even if you end up paying the interpreter a couple $1,000, $3,000. Just saying. Think about that before you just refer it out. You're leaving a lot of potential money on the table. That's why I throw that in there. Okay. Yeah.
Would out-of-state referral be the same?
I'm sorry. Talk louder.
Out-of-state referral?
Yes.
It's the same.
Yeah. It's all broke. Remember, all your referrals though have to be broke. The question was, can you do out-of-state referrals? The answer is yes. You can do international referrals, but remember, they all have to be broker to broker. Remember, in every state, a salesperson has to be paid through a broker. So you have to make sure the referral fee agreement is signed by that other agent's broker. It has that agent's name, but it has to be in the name of the broker.
Is that 25% also?
25% is the customary referral fee. It can be whatever the two sides agree to. There are some agents who will pay 30%. They'll pay 33%. There are some who will only pay 20%. A lot of it depends on the price point in the area they're in. People that are in a low price point, they don't like to give up 25 or 30%. They don't want 20 because they don't make as much money on the transactions. We're spoiled here. We have high priced properties. We make big commissions. So even 75% is a big amount.
Do we have to have our broker to sign a form?
Yes, either Jason or I have to sign the form. Go back to the form. The form has referring broker, referring agent. And then it's signed by the brokerage firm, by the broker or the office manager on both sides. It's right on the form. In other words, you can't enter an agreement with just an agent and you can't share money. It has to be through the broker. So now we're switching gears. You're going to be representing a prospective seller. One of the first documents that's going to get into the hands of the seller, either at your initial meeting or when you're taking the listing agreement, will be the agency disclosure. And they've made this much simpler now. I can't tell you how many iterations of agent disclosures we've had over the years. It's very simple now. This is simply a disclosure signed by your client, no one else, and that takes care of the disclosure of agency. Confirmation as to who represents who will appear in the actual purchase agreement. Now okay, so when you print out a residential listing agreement, it's going to print out the agency disclosure and multiple documents after that. Now, if you're going to list the property, and it's a residential property, which when we say residential, we mean a single family home, a condominium, or a townhouse. That's what we refer to by residential. It's a single family home, it's a condominium, or it's a townhouse. That's what we mean by residential. When we talk about the titles of forms, that's what residential refers to. Now the question will come up, what if the property has an ADU? Because we have another contract called residential income. My recommendation is if you have an ADU on a property that's either attached or detached and is vacant, you can go ahead and use the residential agreement. But when you do your visual inspection, make sure you do a separate visual inspection of the ADU. Because it's particularly when it's a detached structure. You don't want to confuse your comments with respect to which property you're referring to. Do a separate visual as to the ADU. The same applies when you get into residential income. If you noticed at the top of the AVID form, if the property is a duplex, triplex, or fourplex, you check a box and then you state which unit your AVID refers to. We'll see that form when we get to it in a minute. Now, there are other types of listing agreements, which we're going to go through. Now, these are the other forms that automatically print out when you print out a listing agreement. Fair Housing and Discrimination Advisory. Very important, especially these days, because people are sue happy. You know, we talked about allowing buyer letters or buyer love letters anymore, and that's because of conscious and unconscious bias claims that are being made by parties who are unsuccessful in a multiple offer situation. They feel that because the seller has personal information and identity with respect to the buyer, that they may be consciously or unconsciously being biased towards that person and selecting someone else, and that's been resulting in lawsuits. That's why we can't have those letters anymore. Hold on here. Okay, the next document is the possible representation of more than one buyer seller. Again, this automatically prints out when you do a listing agreement. It also automatically prints out when you print out a purchase agreement. Yes.
Got a question. Listing agreement can be used only for single-family condo and townhouse.
That listing agreement, the one I just showed you, the RLA, that listing agreement is for single family home. I'm going to show you about a half a dozen more listing agreements. Okay. You have to determine what's your property to determine which listing agreement you use. For this listing agreement, single family home, condo, townhouse. We'll see all the rest going forward. So this is another important document because this is telling the seller that we may represent a buyer or more than one buyer on the sale of their property, and we may represent another competing seller in the neighborhood. Very possible. If you do your lead generation, once you get the listing, you may pick up another seller. You may pick up the seller right next door. That seller might be more motivated than your seller. You may list seller number one's property at price X, and then meet with seller next door who's more motivated and decides to list their property for less than number one. Your seller needs to be aware of the fact that that could happen.
Or if you do an open house and pick up multiple buyers at one open house, right? Which we're seeing a lot of.
Yeah, and the same thing holds for buyers. You could pick up more than one buyer. I've written offers for more than one buyer on my own listing. Now remember, if you study the terms of the listing agreement, the seller consents to dual agency when they sign our listing agreement. It's in the listing agreement. This is talking about the potential of us being in a dual agency situation, representing more than one buyer and or seller in addition to them. Next, another important one is this wire fraud and electric funds transfer advisory. This is very, very important. This issue is still out there. It's still going on. I've been involved as a broker in 2 wire fraud scams where our agent's email was hacked and emails were sent to the client with instructions to deposit money to another institution other than that, the institution associated with the title company, and money was wired. And guess where those emails were found to originate from? Nigeria. So when you hear about Nigerian scams, they're legitimate. So this is really important. It still goes on to this day. This has been going on for years now. It's still happening. Bottom line is, you remind your client, especially the buyer. The buyers are the ones that are most prone to this, that they do not wire money to anyone without calling the person who reportedly sent them the email requesting the wire to verify that it's a legitimate request. California Consumer Privacy Act, again, privacy laws are very important now. So this reminds the client that we're aware of privacy laws and we do everything we can to keep all the information that we generate private and secure, so that it doesn't fall into the hands of unscrupulous people. Trust advisory. Whenever you have a seller who is a trustee of a trust, and this could be either, husband and wife put their property in a trust, they're still alive, but they're selling their property, and they're selling as trustees of their trust. That's one scenario. The other scenario is the last owner of the property who had property held in trust is deceased, and someone is now taken over as a successor trustee. That's still a trust sale. In both of those situations, the trust advisory has to be part of the listing agreement, because you're telling the seller which disclosures they're responsible for. So they're clear as to what they're required to have, because in the first scenario, when it's husband and wife have a trust, one or both are still alive, they have to provide all the same normal disclosures as any other seller. But if both husband and wife are deceased, the successor trustee takes over. That successor trustee is what we call an exempt seller and has less disclosure responsibilities. And there's a special disclosure form that we'll see in a little bit that addresses that. One other thing to remember is the trust advisory also needs to be part of a purchase agreement when there's a trust sale. So you generate it as a listing agent, you generate it as part of your listing. And if it's been properly, if it's been disclosed in the listing that it's a trustee sale, or if you've provided a pre-sale preliminary title report, they'll see title as trustees. If there's been proper disclosure of the circumstance, the buyer's agent will usually know that there's a trust involved, or the tax report. There's multiple places where it's going to identify the owner as being a trustee of a trust. As a buyer's agent, you should see that, and you should include a trust advisory in your offer. Now, as a listing agent, if you write an offer and you don't check that box and provide the form, then as a seller's agent, I've got to add that to my response to your offer. I've got to incorporate the trust advisory in my counteroffer so that the contract is complete. Because both sides need to know what the seller's disclosure responsibilities are. Because the buyer needs to know they're not going to get as many disclosures from the seller when the seller is a trustee of the trust who is exempt. Probate advisory. Now, this is used if someone can pass away in three capacities. One is they had their property in a trust. Number two is they passed away with a will. Or number three, they passed away with neither a trust or a will. So they're going to fall into one of three categories. If they had a trust, there's no probate. If they have a will or no will and no trust, the sale has to go through probate. Now we used to have a probate listing agreement. Now we have an advisory to the residential listing agreement. So when you have a probate sale, you attach the probate advisory to the listing. Now, when you get in on the purchase side, normally you'll use a probate purchase agreement, but you can use a purchase agreement and attach the probate advisory to it. Normally, in that scenario, when you have a probate listing, the best thing you can do is the listing agent should consult with the probate attorney, ask them which contract they would prefer, and whichever one they want, that's the one you put in remarks and request. Usually, if court confirmation is required, they're going to want a probate purchase agreement. If confirmation is not required, you can get by with a standard purchase agreement and the probate advisory.
Question here. What if the seller is pass away during the listing period?
Well, it depends. If they had a trust, another trustee is going to step in and continue.
What if they don't have any trust?
Then they have to go. Then you would have to stop and go to probate, and the buyer would have to decide whether they want to continue on or not.
Okay. Am I still the listing agent if my seller is dead?
I'm sorry.
I mean, during the listing period, the seller
passes away.
Yeah.
Right, so
Am I
you have to
still the
determine their status to determine which way you can go. If the property's in a trust, the successor trustee can just continue on.
Okay.
It doesn't have to, there's no delay.
Okay.
But if there's no trust, then it's gonna have to go to probate at that point in time.
Yeah.
Because someone has to be appointed the executor or the administrator in order to be able to execute a contract and transfer title.
Okay. But my principal has passed away. Am I still the listing agent?
Yes.
Okay.
Our relationship doesn't change.
Okay.
Now, here's another listing agreement. It's called commercial and residential income. Now, you're either, in our world, you're either a residential agent or a commercial agent. But you can do residential income property. And in the residential world, a property with 2, 3, or 4 units is considered a residential property. 5 units or more is commercial. That's why if you remember, in a lot of the stuff you studied to get your license, it talks about, a lot of laws talk about residential single family 1 to 4 units. You ever run across that? You know how they talk about that a lot? All your disclosures deal with residential single family 1 to 4. 4 units is the cutoff for what we consider to be a residential property. 5 units or more is commercial. Financing is different when you go from 4 units to 5 units. You don't get the same kind of financing. If you're going to list a duplex, a triplex, or a fourplex, or my recommendation, if you're going to list a house with a detached ADU that has a tenant in it, I would use the residential income, because it's going to ask, especially when you get into the purchase side of things, because there's going to be additional information called for in the agreement that you want to generate. Now, if you're going to list vacant land, we've got a vacant land listing agreement. Yeah, now we're talking about residential agent, residential land. Commercial agent, commercial land. If you're a residential agent, you're going to list vacant land, this is the agreement. If you're going to list a manufactured home, that could be a mobile home, that could be a manufactured home. You could have a mobile home in a mobile home park. You could have a manufactured home sitting on a normal residential lot. In either case, this is the agreement you use when you're listing that manufactured home. Now, the one thing I wanted to point out to you is that manufactured homes and mobile homes have their own transfer disclosure statement. It's not the standard TDS. It's not the real estate transfer disclosure statement. They have their own separate TDS. Okay, the next form, a lot of you should be familiar with, and this is the instruction to exclude a listing from MLS. Remember, when you take a listing under BAIS MLS rules, you have to put that property on the market within 3 days or provide this instruction to the MLS to exclude it from the MLS. And the mistakes I see quite often are boxes are checked in paragraph 3. BAIS adopted the clear cooperation policy, which means you do not check boxes in paragraph 3. You complete paragraph 4 if you're going to exclude it. A comparable form that can be used rather than the zip forms is you can use the form that BAIS has, and then it actually gives you the email addresses on where to send it. Moving on, this is an instruction if your client doesn't want the listing to go on the internet. Here's the form for that. You get people that are all freaked out about their privacy and not wanting pictures of their house and their personal property to show up on the internet. Well, I wouldn't recommend excluding your property from the internet because that's where 99% of the buyers are going to see it. But if that's what you want to do, here's the form to document that. Because that's gonna come in real handy when their property's not getting shown very much and they're not getting many offers because they're not on the internet.
So that's like a off market.
Commission agreement. This is an alternative to a listing agreement. This can be used in a situation where you're selling it off market. You're not doing any internet. You're not doing any kind of traditional marketing. And your seller says, I mean, do you have buyers for this property, or or maybe the seller knows a couple people. You can enter into just a straight commission agreement for a set period of time to be paid a commission. There could be an agent on the other side to handle the sale, but it's not being done through MLS. There's not being marketed and so forth.
So just to be clear, though, you still use a listing agreement in addition, no listing agreement whatsoever.
This is just a straight agreement to pay a straight commission.
Okay.
Because there's another one you can use called a single party compensation agreement. This is where you've got the seller already has a buyer, family member, a neighbor, whatever, and they want you to handle the transaction. This allows you to get paid if you sell the property to that specified buyer, single party. You name the buyer in this document. I've used this multiple times over the years, where I get a seller comes to me with a buyer. Sometimes it's a family member, and they want to sell it to the family member. And I don't use a listing agreement. I just use this agreement, just to document that I'm going to get paid for handling everything for that transaction. And you designate, agencies all accounted for in you're only seeing one page of the form. See, just understand, everything I'm showing you is page one. A lot of these forms are multi-page forms.
So do you represent the buyer and seller?
Yeah. More often than not, I do. I represent both buyer and seller.
How do you get paid? Just like the function?
Yeah. Well, no, depends on there's a different way to take that through to determine how much you're going to get paid. I start with 6, and I've got a way that I analyze it to drop it down from 3 and 3 to 2 and 2. And then depending on whether I go from 2 and 2 to 1 and 1, depends on what I'm doing, depends on the seller, depends on the buyer, depends on their relationship, depends on whether financing is involved, whether the buyer's already been pre-approved, whether there's inspections still to be done. There's a whole host of things that come into how much I'm going to agree to receive to handle that transaction. The more work I've got to do, the more I'm going to get paid. The less work I do, I'm willing to take less. It depends on who the client is too. If they're a past client in my sphere, or if it's a family member, I may be willing to do it for less than if it's a stranger. Just depends. Yeah, you guys always want that silver bullet, the magic answer. It depends on the situation what that number is. And ultimately, it's up to you.
It's not gonna hit the MLS, right? So.
No, it's not going to hit the MLS. It's a straight off-market sale. Seller and buyer, normally seller and buyer have been brought to you.
And how about the exclusion form? You still have to.
No, because you didn't list the property.
Okay.
You didn't market it, you didn't list it. I've had numerous occasions where I've dealt with this, and every one of them is different because it depends on the situation. Not to belabor the point. Invariably, what happens in this situation is the parties may have agreed on a price. Maybe. How long is the purchase agreement? 10 pages. What else have they agreed to besides price? Usually nothing. Okay? So you got to hammer out all the remaining details of the contract. Are there going to be contingencies? Is there going to be financing? Is there going to be appraisal? Are there going to be contingencies? Are there going to be inspections? See where I'm going with this? So you're going to be doing a lot of the same normal work. and it's even more work when they haven't agreed on the price. Now you're doing the same, you're sitting down with the seller, doing a market analysis, agreeing on a price to ask. Then you're sitting down with the buyer, and go, all right, the seller wants this for the property, here's a market analysis. How much do you want to offer? And you've got to do everything that you would do in a normal transaction. But you don't have the marketing of the property, and you're not holding open houses or doing anything to generate the buyer. So there is some substantiation for taking a lower commission in that situation, because there's work that you would normally do that you're not doing, but you're still doing a lot of work. Okay, now if there's going to be more than one broker representing one party or the other, you have a form for that now called additional broker knowledge. We went for years and years without these forms. Now we have an additional broker knowledge. There's going to be co-brokers. Next is if you have multiple agents within the same office that are going to work either a listing or a buyer. You've got an additional agent acknowledgement where you list the different agents who are working it. We have that in this office. We have deals where there's more than one agent working it. And we have, which is great to have, is make them figure out how they're going to share the commission up front. So we don't have to deal with it when it's getting ready to close and we're trying to submit a demand and we have a disagreement as to how much each side is supposed to get paid. Each agent is supposed to get paid. So we have an agreement. And it's 4 pages long just for sharing the commission.
This one is co-listing.
Yeah. Yeah, when you're talking about a co-listing, yeah, you got a co-broker. That's what you use these forms. Okay, this form here is authorization to receive and convey information. You need to be, back in the short sale days, we needed this form signed by our sellers to provide to their lender so that we could negotiate a modification of their loan in the short sale to get the property sold, because we were selling the properties for less than what was owed on the property. So we needed written authorization from the seller to negotiate with seller's lender. You'll have situations sometimes where you may go to talk to a service provider, a utility provider, an insurance, number of different vendors that you may try to talk to on behalf of the seller, and they won't want to talk to you unless you have the seller's authorization. So that's what this form is for. See, some people really follow privacy rules to the T and others don't. Someone who's following privacy rules to the T, I mean, how many times have you called on behalf of somebody and they say, I'm sorry, I can't talk to you. You're not on the account. I can't talk to you for privacy reasons. If you're trying to talk to somebody on behalf of the seller, this is the form that'll get you in the door for them to talk to you.
I have a couple questions. Number one, does the single party naming the buyer also take place of the purchase agreement? Okay, we'll get back to it.
I'm the listing broker. Once I have an agreement, my compensation is in that agreement. It doesn't need to be addressed anymore. If you go back to the purchase agreement refers to the commission referenced in another agreement. What's that other agreement? It's either the listing agreement or, in this case, the single party compensation agreement. See, I have a writing that memorializes the commission, that agreement. It doesn't need to be brought up again. It's already there. Because remember, who's paying the commission? The seller. It's already done. We don't resurrect the listing agreement when we enter into a contract. The contract refers back to the listing agreement that's already in existence by its terms. Same thing applies to this agreement.
Okay. Then if the agents are listed on the purchase agreement, do they need the AAA form, the additional agent acknowledgement form? If they,
Yeah, they can, there's no room for a second agent on there's only room for one. That's why they did this form, because none of the paperwork is set up for multiple agent brokers and agents. That's why they had to create these forms, because they were all set up for single brokerage.
And then on the ARC form, how does that compare to a power of attorney?
It's not the same. Okay. Power of attorney in our world, we will never have a power of attorney for a client. It's a conflict of interest. If you ever have a client that wants to give you power of attorney, you got to say, I'm sorry, I can't represent you. I can't be your agent under a power of attorney because I have a conflict of interest. They have to go find some other family member, close friend, co-worker, someone else. And remember, in our world, when we talk about powers of attorney for purposes of selling real estate, 99 out of 100 times it will be what we call a special power of attorney, meaning it will be specific as to that property and nothing else, as opposed to a general power of attorney or a durable power of attorney, which would apply to almost anything and everything with regard to that person's financial affairs. Take care of that.
Yeah, I think so.
Market conditions advisory. Again, this is another form, especially now, that's really important to get into both buyers and sellers' hands. There's not much, I didn't put it, that there's only one section in this form in the back dealing with sellers, but it's still a good idea for them to be given the form so that they're aware of overall market conditions going forward. Especially if you have someone that hasn't sold a property in a long time. They're not going to understand what's going on in today's market. Okay, estimated seller proceeds. This is something that we have not really done much as normal practice in our business. And I think a lot of it has to do with the fact that the prices of properties have gotten so high that the average seller really isn't worried about all the details and all the costs to really be concerned about what their net's going to be from the sale in a lot of cases. So therefore, they don't really ask for what we call a net sheet, which is referred to as estimated seller proceeds. The reason I put this up here is because you're going to have situations where they may ask for it. Now, you've got a couple of different ways you can go with this form. One is you can ask, if you've opened up a pre-sale escrow, you can ask the escrow officer to prepare an estimated settlement statement. But you're going to have to give the escrow officer a price. You're going to have to give them a close date. You're going to have to give them an estimated payoff demand on their existing loan, if there is one. You're going to have to give them a commission amount. So there's a bunch of different things you're going to have to give the escrow officer. But if you do that, you also got to be careful with city transfer taxes. So there's at least a half a dozen different specific things you're going to have to provide to the escrow officer, but an escrow officer could prepare an estimated settlement statement for you. The alternative is you create it yourself, and you can, most of the information you're going to know by virtue of your familiarity with the property and the area where it is, and you can rely on past settlement statements from prior transactions you've done, or ask somebody for a copy of one they've done, and then you can pull out the various fees and prepare a net sheet. Now, there can be, see, in the old days, we did this when we took the listing. We didn't walk away from their house without showing them an estimated net based on the price we listed their home for. Now, it could be as many as 3 times where you could generate this. One is up front when you take the listing, and you could generate a net sheet based on the list price. Another is when an offer comes in, or even multiple offers, you generate net sheets for the offer that was written. And then assuming it's not acceptable and you negotiate, when you finally get to the final contract price, you could be creating a third one as to the actual contract price. That makes sense? Now you're showing the seller what they are likely going to net, assuming no changes in the terms of the contract going forward. Now, what might be a circumstance where that would be important or critical for the seller to know as soon as possible? Anybody think of a situation where the seller knowing what their net's going to be is going to be relevant to them accepting let's say, a counter offer that's been made?
Well, if they want to get another, like, move to another property,
Say a little louder.
if they don't want to get a new house or move to another
Yeah.
property, they have enough funds to.
Exactly. Okay, good answer. Yeah, if they're selling to buy another property and maybe they've got their eyes on a particular price property and they know how much they can qualify for a new loan, they need to know how much they're going to net in order to make that sale go through.
Mhm.
Also, if it's a successor's trust sale, means like the seller's parents have passed away and the seller has to sell this house and then he has to pay for the tax. So in
Pay
that,
what tax?
capital gain,
That's all going to pass through to the beneficiaries. The
okay.
trust does not, when you have a trust sale, you have beneficiaries in a trust, the trust doesn't pay the tax. It flows through to the beneficiaries. The beneficiaries pay the tax.
Pat brought up 1031s.
That's the answer I was looking for. 1031 exchange is the situation where you need to know what the net is, because that's going to tell you how much you've got to spend on the next property or properties in order to defer capital gain. So that's why you want to know what your net is, because remember, as soon as you're ready to negotiate a deal, as soon as you ink the deal, you've got, let's say it's a 30-day escrow, 30 days are starting to click off. And once 30 days comes and it closes, now you got a 45-day identification period after that 30. So you got theoretically, you got 75 days from the day you enter into a contract to identify a property or get in contract on a property. And that can go pretty fast, especially in this market. So you need to know right away, how much money am I dealing with? What do I got to spend in order to make this all work? And we'll cross our fingers and hope that 1031 exchanges survive whatever tax law changes are coming out of Washington, D.C. over the next 2 to 4 to 6 months. This form is much simpler to do now because it's intuitive. When you put in certain dates and put in certain dollar amounts, it will automatically do a lot of the calculations for you. So it's a little easier now than it was when I first started. Okay, anyone ever hear of excuse me, potentially doing a lease with an option to buy? Anybody ever hear of that concept? Where you enter into a lease agreement with a tenant and then you give them an option to purchase the property in the future. So we have the forms for that. Now, the way that works is you're actually going to be generating 3 documents. You're going to be generating a lease, you're going to be generating the option to buy, and you're going to be generating a purchase agreement. Now, that purchase agreement could always be subject to change depending on the market conditions and so forth. But you initially can generate all 3 documents at one time. The way they generally work is you can, there's an agreement, there can be an agreement to sell the property in the future at a set price, or it could be an agreement to sell it based on fair market value, subject to an appraisal or an average of 2 appraisals, or multiple ways on how you could determine the price in the future. But the tenant can get credit for some or all of the rent that they're paid towards the purchase price, and they pay what's called option consideration up front. They pay money up front for the option to buy, and that could be any amount. That could be $5,000, it could be $10,000, and whatever. And that money is non-refundable. It's given to the landlord, and the landlord keeps it, whether they go through with the option or not. And normally the rent's higher than normal to establish, arrange to be able to apply a credit for a percentage of that rent towards the purchase price as well. How do you get paid? Okay, and the ones I've done in the past, I will generally, if I'm gonna get 6%, I'll generally get 2% up front upon execution of the lease, option, and purchase agreement. I get the remaining 4% if the buyer goes through with the deal and buys it. Okay, so it's a two-step process on payment. A third of it when you execute the paperwork and the tenant moves in. The other 2/3 at close if the tenant goes through and does buy the property. Okay, it's useful in a strong buyer's market where you're having trouble finding buyers. It's useful to use with a tenant who can't qualify right now. They don't have enough money now, but you're going to give them an opportunity to build up a bank of money through this option and through a percentage of their rents being applied. I did one for a seller, and the rent that the buyer could no way qualify for a loan. We charged rent such that it covered my seller's total monthly expense. Yeah, no negative cash flow. And the guy went for like 3 years. He never could build up enough money for a down payment. He moved out and then we sold the property. But my seller was like, he was receiving, he had no negative cash flow, and then he still turned around and sold the property. So he was happy. Question?
Is there a time limit?
Well, you set time limits in the document. You tell them how long the option's for. It could be a year, 2 years, 3 years. Yeah. Remember, that's a 3-page document. Oh yeah. Any contract has to have a time limit in it to be enforceable. If you don't put an ending date in an agreement, it's not enforceable. It has to have an end date. And it's whatever the parties want to agree to. And then this is a copy of the residential agreement that would be part of the package. And that's, what is it up to now? It's 8 pages now, the rental agreement. That's how you deal with an option. One thing I recommend when you enter into an option agreement is at a minimum, have a pest control inspection done before the tenant moves in, and even better, also do a property inspection. So basically you establish the baseline for the condition of the property. So when it comes time to sell, if the condition is substantially changed and it's caused by the tenant, the seller is going to say, this is an as-is sale. I'm not improving the property because you're the one that caused all this damage over the years. Okay, and that's how you establish the condition. Let's say you're in a situation where let's say your buyer's the tenant's a veteran and is going to want to try to do a VA loan, down the road. Well, a Section 1 certification could be required. Well, you're going to be negotiating who's paying for those repairs. If you've got a baseline showing condition is X and it only needs 5,000 work, and then when the tenant goes to exercise, it needs 10 or 15,000. Well, who's paying for that extra 5 or 10? Landlord's going to say, tenant, you're paying for that because you caused it all. Does that make sense?
Does it affect the landscape?
Pardon?
For the landscape or just for the structure?
What, the section 1?
No, like the tenant, once the tenants came into the house.
Uh-huh.
And he destroys the landscape.
Well, he's still buying the property as is. The seller's not gonna do anything. The property's gonna be sold as is. The seller's not gonna improve the property. All right, representative capacity signature disclosure. This document, you've got to, you potentially use that listing and at purchase. This is, in this scenario here, we're talking about the RCSD-S, which is representative capacity signature disclosure for a seller. This is when your seller is trustee of a trust, or the individual has an entity formed like a corporation, an LLC, or a partnership. The person who's selling the property is selling it under a power of attorney, typically a special power of attorney, or you have an estate sale, where it's an estate or a conservatorship or a guardianship. Which means it would, now we're in, when we see estate, that means probate. Does everybody understand all the different entities we're talking about? So you're gonna, you stay in this business long enough, you will likely run across all those scenarios, particularly on the seller side. And even specifies whether the power of attorney, under power of attorney, specifies whether the power of attorney is a general or a special. And you can, just so you know, you can, generally speaking, if you have a situation where you need a special power of attorney, it happens a lot between husbands and wives. One of them travels a lot for business and is not going to be around during the contract process or the closing. That spouse can give the other spouse power of attorney. Now, normally, if it's a spouse, it's going to be a general power of attorney. It's not going to be a special. And then that way, the spouse who remains here can sign for both of them. That makes sense? You understand the scenario there? It happens a lot. And you can have the escrow officer will prepare the power of attorney. I've done that many, many times. You just give the escrow officer the names and then set up an appointment with whoever's giving the power of attorney is the one who has to show up, because they have to sign that power of attorney before a notary. And then that power of attorney is used going forward. Additional signature addendum. Our forms are set up for 2 sellers or 2 buyers. So if you have 3 sellers or 4 sellers, you need to use the additional signature addendum for the listing. You also use it when you have more than 2 buyers. And then the benefit of having it when you have that 3rd or 4th buyer is that they are able to initial their agreement to binding arbitration and liquidated damages on that form, and they don't have to touch the 10-page form. All you need for that 3rd or 4th seller or 3rd or 4th buyer is that form. But then you've got to generate it for every form thereafter. So if you generate a counteroffer, so you got, I've had sold property where I had 3 sellers, 3 siblings. So that 3rd sibling signed a ton of additional signature addendums, because every time I generated a new document, I had to generate this. Now I'm okay, like if you're doing disclosure documents, I'm okay if on the other section on top, you just type in all the acronyms for all the disclosure documents. I'm okay with that. You don't have to do one of these for each separate document. So remember, the reason this is all generated is because we're doing a large majority of our signing is being done electronic. So we have to have forms to put everybody's signatures in a logical, legible place. We can't have people initialing and signing all over the paperwork. That's why we have these forms, so that everything's generated. Is everyone clear on what I'm saying? You're a listing agent. You take the listing, You then prepare anywhere from 3 to half a dozen disclosure documents. Those all have to be signed by all 3 sellers if you have 3 sellers. So the 1 and 2 are going to sign the original documents. Number 3, you're going to prepare this document. Under other, you're going to list each disclosure document, and then they're going to sign that document, which is the equivalent of them having signed the original disclosure document. Does that make sense? Now, you should make sure you provide them with the forms that they're signing for, so they know what it is they're signing, to make sure they're in agreement with what the information contained in there, especially when it comes to disclosures. Because remember, all sellers have a duty to disclose material facts. Any fact of which they're aware of that may significantly affect the value or desirability of the property has to be disclosed, even if it's not written in a form. When you have siblings, they may know something about brother's property or mom and dad's property that's not listed anywhere on a form. They've got a duty to disclose that if it's a material fact.
So just mark other and RLA will be typed there, or mark RLA and other, and then.
Well,
attachment.
Yeah, at the listing side, all you're doing is the RLA. Typically,
Right.
they're not completing disclosures at the time you take the listing. You're generating the disclosures after that, and you're creating the ASAs for those disclosures as another process.
As a buyer, when.
As a buyer, you're going to be checking the purchase agreement. If you've got 3 buyers, you're checking the residential purchase agreement. See, if you read the contract carefully, ahead of the signature blocks for buyer and or seller, it refers to representative capacity signature disclosure, and you check a box and you generate that form. And then after the signature blocks, it has another box for additional signature addendum, meaning there's a 3rd buyer or a 3rd seller or a 4th buyer or a 4th seller. Not uncommon to have 2 married couples own a property 50-50. I have clients right now that I'm doing trusts for both of them. They're 2 brothers with their wives. They each co-own 2 rental properties that I sold them. So if they were to, and I'm finally getting these properties in their trusts. If they were to sell one of those properties, 2 of them would sign the original listing paperwork and contract. The other 2 would be signing these documents. Okay, modification of listing, buyer representation, or other agreement between principal and broker. So this is a form where if you're going to modify the price of a listing, you're going to do a price adjustment. This is the form. If you're going to change the expiration date, listing's getting ready to expire, and you're going to extend it for another 90 days or however long you're taking the list. You're going to they're going to agree to extend it. You put in the new expiration date. If you're going to make any other change, if there's going to be a change in the commission, anything else is going to change with respect to that listing, this is the form you have them sign. And this would apply to the buyer representation agreement too. Hopefully you don't have to use this one too often. I don't teach a lot of classes about cancellation because I always hope we're not going to have to deal with it much, but it does happen from time to time. And I have to admit that I've been advising agents on this form more in the last 60 to 90 days than I probably have in the last couple of years, because we're seeing, how should I describe these sellers? Unrealistic sellers or greedy sellers expecting to get a price above the asking price, but it doesn't come in quite as high as they were expecting or hoping. And they decide they don't want to continue to go forward. That's the situation that I see more often than not. Again, there's multiple methods of consideration if there's going to be a cancellation listing. First thing you need to understand, a seller does not have a unilateral right to cancel a listing, period. Nowhere in the listing agreement does it talk about the seller's right to cancel. I just saw something online. It was a Facebook post, I think, and someone posed a question about, how do I cancel a listing? And someone who I'm sure wasn't a broker or agent said, "Oh, it's no problem. California is an at-will state. You always have the right to terminate." I was so tempted to get on that site, but I said, no, I'm not going there. I don't want to go down a rabbit hole and get into that discussion.
I saw that one.
Did you see that one? Yeah, it was in the Bay Area.
Bay Area.
Yeah,
it's
yeah,
all
yeah,
straight.
exactly. I'm just going, no, I'm not going down that rabbit hole. I don't have time. Just understand, a listing only gets canceled if we agree, and it has to be on our terms. If a seller could unilaterally cancel a listing agreement, why would we even have them? I mean, are you going to go spend? I mean, I have a listing right now, folks, where I'm spending over $1,500 a month in marketing. Not the whole period. Over $1,500 a month I am spending in marketing fees. You think I'm going to do that if the seller could just pull the plug on me at any time? Say no. Of course not. So, if you hear anybody out there talk about, a seller being able to cancel a listing agreement, you got to take time out. I don't have a right to cancel. Now, if you're not doing your job, if you promised a whole bunch of stuff and you're not doing anything, and I get the call from your disgruntled seller, and they're complaining about how you promised to do this, and this, and you haven't done any of it, I don't have a great defense in that situation. Do you think I get those calls? Say yes. Do you think they're fun calls? No. Those are the kind of calls when I get off the phone, I go, this is one of those times where I wish I wasn't a broker. Because they're not fun. They're not comfortable. And you know how they talk? They don't use your name. They don't use my name. It's Keller Williams. Keller Williams did this. Keller Williams did that. It's like and they just berate you. Then it makes you feel like you're this big when you're all done. Now, sometimes I'm able to salvage the marriage, so to speak. You may or may not know that, depending on the situation. Once in a while, the relationship has been so bad and the seller has been the one who's been the wrongdoer. It's like, we don't want anything to do with it. However, because of the amount of time and money we've invested in it, we're not letting them go without getting paid money. And that's what this document provides for. You can say, yeah, we'll cancel the listing, but you're paying us this much money because here's how much time we spent, here's how much out-of-pocket expense we've got in this deal. It takes the right set of circumstances. You have to understand it. There's a PR aspect to this too, depending on who this person is. If they're a good client of yours and there's going to be circumstances where we're not going to argue at all. We're just going to cancel the listing and they're not going to owe us a penny because you want to retain that person as a client. You want them as a referral source. You don't want to tick them off. But sometimes you get someone that you could care less about when it's all said and done because they treated you like dirt. And I've seen that happen too.
So a question came up, we talked about this the other day, that if you listed the property, you got, let's say, multiple offers above asking price, you got them everything they wanted, but now they want to cancel the listing. One, what's your option? And two, have you ever actually come across it and gone after that commission?
We can sue for the commission if we've satisfied the terms of the listing agreement. We can sue. The problem is if we want to go for the total commission, we've got to file that claim in Superior Court, which means we've got to hire an attorney to file that claim. And that's going to cost, that could cost just as much. I'm not joking here. Just as much, if not more, than the commission.
Is that because it exceeded small claims amount?
In small claims court, the jurisdiction is $10,000. However, the jurisdiction is only $5,000 for a corporation. And we are a corporation. So, and we've gone to court once on a buyer rep agreement. Buyer went to a new home development. Didn't take the agent, was told, didn't take our agent, went to a new home development, and we went after the buyer for $5,000. I think which court did we go to? If we went next door or Pleasanton, I can't remember what court we went to. We went to small claims court. We won. But guess what? The defendant can appeal a judgment against them to Superior Court and have the case tried again. So that's what the buyer did. She appealed it. We had to go to Superior Court in Hayward, and the case is tried again. And the judge, as soon as she opened her mouth and started talking, I whispered to our agent, I said, "We're not going to win. She doesn't like real estate agents." It was obvious. I don't know if she had a bad experience, but it was clear to me she did not like real estate brokers and agents. And I said, "We're not going to win this one." And so we argued the case, same arguments that won, with the judge in small claims court, argued the same. Waited for the verdict to come back a couple weeks later. Sure enough, she reversed it. So we went to court twice and got nothing, had nothing for it. Remember, it's a PR decision that we have to make. You don't know who that person is. You don't know who they're going to go talking to. Oh, Keller Williams, I'll never work with them again. They sued me for a commission. See, that's what goes through my head when I have to decide whether I even want to go down that road. Enough said. Moving on. This is now when you do a cancellation of the listing or you have an expired listing, remember there's a protection clause in there. Everyone know what I'm talking about a protection clause? After you put the total commission, the next paragraph talks about for how many days after the expiration or cancellation of the listing might you be entitled to a commission if the property is purchased by someone who was shown the property. And you give the seller a list of those buyers. That's the document you use for doing that. I know of a situation in this office where we had a listing, it was over $2 million. And the listing agent failed to provide that form as to one buyer. And guess who bought that property? That buyer. And our agent didn't get paid and would have had that form been submitted to the seller. Now, it used to be this form had to be provided to the seller within so many days after the expiration or cancellation. Now it has to be provided at the time of the cancellation or expiration. Notice the sale and entry. This is a very important document when you're listing a tenant occupied property. This is a notice that the law allows. You serve a notice on the tenant and it says for the next 120 days, tenant, agent can enter the premises during normal business hours with 24 hours oral notice to show the property to prospective or actual purchasers. That's the law. And you serve that notice on a tenant. And if the tenant does not allow showings, number one, they're violating the law. Number two, it's a breach of the rental agreement, because all rental agreements have a cooperation clause in them. So the tenant is now, the problem we have right now is because of COVID and backlogs in the court, it's not easy to go to court to enforce these situations. But again, I'm telling you what the, what the laws are. And everyone goes, well, what's normal business hours? I go, well, 9 to 5, 8 to 6, 9 to 6. I mean, you're pretty safe with 9 to 5. It's kind of hard, it's kind of like the movie, kind of hard to argue, hours other than 9 to 5. But, and that's not necessarily ideal for a lot of people, because people work during the day and they'd rather look at the property at night.
But before you go to the next one, could we actually take like a 8-minute
Yeah,
break?
I was looking at the clock, assuming. that
We're at an
clock was
hour
good.
and a half.
Yeah,
right now.
yeah. So we'll take a 8-minute break. Yeah.
Yeah.
Okay, we'll
Oh,
start.
because that brings us 2:40.
Yeah, we'll start back at 2:40.